Have you ever been in an argument where the whole thing comes down to one tiny detail that everybody just missed? Well, today we're going to unpack a real-life dispute that's exactly like that. It's a classic story of assumptions, strict rules, and a missing deck railing.
And this really gets to the heart of the matter, doesn't it? Can you actually get in trouble with your HOA for doing something that just seems like the next logical step, even if you didn't get it in writing?
So, this whole thing goes down in sunny Scottsdale, Arizona, at a place called Gainey Ranch. And the big point of contention, the object at the center of this entire legal mess, you guessed it, a deck railing.
So, how in the world does a piece of metal on a deck end up in a legal hearing? Well, let's meet the players in this little drama.
On one side, you've got the homeowner, which is technically a company, MS Pavillions 35 LLC. And on the other side, the Homeowners Association, or HOA, the Gainey Ranch Community Association. It is the classic homeowner versus HOA showdown.
So the HOA files a formal petition, and they lay out the crime pretty clearly. The homeowner took down a deck railing without getting approval first. I mean, it sounds simple enough, right? But as we're about to see, it is anything but.
Now, as you can probably guess, the homeowner had a very different story. From where they were standing, what they did was totally logical and, basically already approved.
And this quote right here, this is the core of their entire argument. They're basically saying, look, you can't separate these two things. You told us we could install the new fascia. To do that, the old railing had to go. It was a package deal you already signed off on.
Okay, let's just walk through their thinking here. It seems pretty straightforward, doesn't it? Step 1, they get the green light for new metal fascia on the deck. Step 2, they figure out the old railing is physically connected to the old fascia they have to rip out. So, step 3, they just assume that taking off the railing is part of the approval they already got. I mean, it kind of makes sense.
And get this, there was another layer to it. When the contractor actually took the old railing off, he found it was a complete mess, rusted out and rotting away. There was no way they could have put it back on, even if they wanted to. So that just makes the homeowner's decision look even more practical, right?
But the HOA, they saw things in much more black and white. For them, all these assumptions and practical details, they didn't matter one bit. The only thing that mattered was what was written on that piece of paper.
And wow, this slide just lays it all out, doesn't it? What got approved in that committee meeting? New metal flashing at patio, super specific. What was not on that approval? Any mention of touching, let alone removing, a deck railing. For the HOA, if it ain't on the paper, it didn't get approved. End of story.
So you might be asking yourself, how can they be so strict about this? Well, it all comes down to something called the CC&Rs. Think of it as the legally binding rule book that everyone agrees to follow when they buy a home there. It covers everything.
And the rule they pointed to? It's about as airtight as it gets. Just look at the language here. No exterior changes whatsoever. The key words are whatsoever and prior written approval. And let's be honest, taking down a whole railing, yeah, that's definitely an exterior change.
So we're kind of at a standoff here. The homeowner's argument for implied permission seems logical, but the HOA's rules are rules argument is also hard to ignore. So how does a judge decide something like this? Well, it all boiled down to one single crucial detail.
So what was it? What was that one little thing that completely tipped the scales and unraveled the homeowner's entire argument?
Believe it or not, the answer had nothing to do with the new renovation. The secret was hiding in an old renovation, one the homeowner did himself and one the HOA had absolutely no clue about.
And here it is. This is the bombshell from the judge's final report. The only reason the railing was attached to the fascia in the first place was because the homeowner himself had moved it there during a previous project. It wasn't designed that way originally.
And with that one fact, the homeowner's entire defense just falls apart. I mean, his whole case was built on the idea that the HOA should have known the railing had to come down. But how could they possibly have known when the homeowner himself created that exact problem without ever telling them?
So, once that little secret was out in the open, well, the path to a final ruling became very, very clear. And the verdict was crystal clear. The judge found that, yes, the homeowner had violated the community's rules and ruled completely in favor of the Homeowners Association.
And what was the price tag for this unapproved project? The homeowner was ordered to cover the HOA's legal filing fee, which came out to $550.
So to wrap up the judge's final order, it was pretty simple. First, the homeowner has to follow the rules from now on, which means getting proper approval for a new railing. And second, they had 30 days to write a check for that $550 to the HOA.
Which brings us to the big takeaway from all this. This whole case is a huge cautionary tale about the danger of assumptions, especially when you're dealing with contracts and rulebooks. So before you start your next project, it's probably a good idea to ask yourself, what am I just assuming everyone understands? Because as we just saw, one little unspoken assumption can end up costing you.